and Exhibit 14C. Can you just explain that to me? So, is JS2 covering all the relevant technological evidence, including the BlackBerry belonging to Mr. Palmer, or is it not?
No, JS2 is the material that was obtained from Digicel, which is why the issue of the compliance with the relevant legislation was an issue. 14C was the download from, I think it was the BlackBerry, was it? Yes, it's from the BlackBerry. So 14C was a separate. It was effectively a separate issue.
So we're not dealing with.
We're not dealing. No, exactly.
We're dealing simply with JS2. And just in outline summary, what did that include? They were the conversations, as I understand it, between. Sorry.
No. Sorry, that was rude of me. Sorry.
Well, I was going to say the conversations between the deceased and his girlfriend. Is that right? While travelling, allegedly.
Yes.
Yeah, and then does it also include Mr. Wee, evidence in relation to what he?
You mean Mr.
Chow?
Sorry, yes, there is evidence, there was communication in relation to Mr. Chow. Possibly the best summary, which is what I was going to, I mean, obviously, in one sense, one of the reasons for not focusing on what it concerns is that in relation to the jury issues, the Crown's case is the matter was overwhelming in light of JS2, which demonstrates in one sense its significance. The summary, though, of what it included is paragraph 155 of the Court of Appeal's judgment.
Thank you.
Page.
Page, sorry, yes, 5837.
Thank you.
It's also just worth noting paragraph 24 of the Court of Appeal's judgment, which notes how that also sumarises the evidence and notes in particular, it goes to the point my Lord just raised about Mr. Chow, and that's 5783, paragraph 24, and that's relevant because it notes that this material was relied on to show constant communication between the defendants and Mr. Chow. It also was then the basis, there was a certain amount of cell site analysis, and it was the basis of that. And you see that in the trial judge's summing up at 5071, paragraph 13. Not paragraph 13, line 13. And just to put it in context, one of the reasons why it was also relevant was this was a case where the live evidence, essentially in relation to Mr. Chow, had real question marks against it, and that's in one sense demonstrated by the acquittal of Mr. Williams, who was a defendant the Crown's case entirely consisted of Mr. Chow in that case. So where Mr. Chow was the sole evidence, there was an acquittal, essentially.
So, just so I'm absolutely clear, so the evidence in relation to what Mr. Palmer had on his BlackBerry is not part of what we're now concerned with?
No.
What about the video in relation to Mr. Chow?
Can I just double check on that with my team? But I don't think that's within the material. I don't think that's within JS.
That was in 14C, as I understand
it. Yes, that's right. Yes. Yes.
So 14C is completely out?
Yes.
Yes, thank you very much.
Mr. Southey, paragraph 155 of the Court of Appeal doesn't so much summarise the contents of JS2 as the use to which it was put. JS2 was put by Corporal Brown.
Well, yes, but in one sense that's of some importance in the sense that it demonstrates in one sense how important JS2, because JS2 was raw data which was then presented by Corporal Brown through effectively his own interpretation of it. So that's why the summary is there, because he was effectively presenting the evidence.
Where do we find a summary of the contents?
I'm not sure there's a... Sorry.
No, I think it's fair to say one doesn't. My lord, I have done a trail to find out exactly what was on JS2, and I've recently seen what appears to be JS2, which entirely fits the summing up. But I can tell you what it contains now, or wait until I begin.
It would be helpful for us to know what it contains.
Yes. And perhaps, Mr. Studley, if I say what I believe it contains, Mr. Studley can then take instructions. My lords, what JS2 was the disk, as I understand it, and then from that disk, Corporal Brown drew up a spreadsheet, various spreadsheets. Now, the first spreadsheet consisted of texts. Second was a spreadsheet of phone calls. And it was drawn up, these spreadsheets were drawn up from 4 telephone numbers. That is to say, Mr. Chow's phone number, the deceased's phone number, Mr. Palmer's phone number, and Mr. Campbell's phone number. So they were the only phone numbers which were the subject of JS2, A, in relation to texts, B, in relation to calls. Now, as far as the texts were concerned, what they consisted of was the following. Text between the deceased and his girlfriend on the 14th and 16th of August 2011.
16th
of August 2011, that being the day of the killing, we say. Those texts are summarised in the summing up at E4788 to E4791, and we also summarise them in our case at 6227 paras 40 and 41. But essentially, they're the ones where the deceased is saying, I'm getting more worried. The second set of texts are to and from Palmer between the 8th and the 12th of August 2011. But they appear to be of no importance at all. They don't appear to be referred to in the summing up. They were read out to the jury, but they don't add anything. The third set of texts were those from and to Shawn Campbell, which are, to an extent, incriminating, and they are referred to in the summing up. They suggest that on the day of the killing, but before the killing, Campbell knew that the deceased was going to be executed. He had to die. And they suggest that after the killing, he knew the killing had taken place and they needed to get away. And you can see a summary of those texts at, in summing up, at 4989 to 4991, broadly. That's where they're set out and explained. And importantly, my lords, it is a point you may have wondered, what about the other defendants? Now, it does seem as if texts were collected from the other defendants' phones, but they, after the voir dire, were excluded. And that, therefore, means there are no texts passing from St. John, passing to and from St. John, or Jones, or Shane Williams. They were originally in the original exhibit before it got to the jury, but by the time it got to the jury, those texts were all gone. As far as the call of telephone logs is concerned, that ran from the 10th to the 17th of August 2021, and what they did was indicate the nearest cell site which picked up the respective calls. And they did show, again, when Palmer was receiving or making a call, likewise Campbell, likewise the deceased, and likewise Chow. I should say, and Chow. There don't appear to have been, as far as I can make out, any texts from Chow. So that's the nature of JS2. But the only really incriminating material in JS2, as such, are the text messages passing to and from Campbell shortly before and shortly after the killing. I say incriminating. Of course, those between the girlfriend and the deceased were incriminating, but they are not from Campbell, they're from the deceased's phone. I think I've given you the references where you can find it all in the summing up. We don't summarise all of it in the case, but we do summarise quite a bit of it in our case. We have tried to get hold of, I think it was Exhibit 10. There are some difficulties getting hold of Exhibit 10, that's all I can say. I have seen what we believe to be Exhibit 10 in relation to the texts. I was handed another exhibit, which plainly was the unedited version in relation to telephone calls. So we haven't put that in. But we can make available what I believe to be the exhibit in relation to text messaging.
And did the judge sum up in relation to the cell site evidence?
No, not really, apart from what you've just shown. I think it's fair to say not much appears to turn on the cell site evidence. I will address you later as to why I say very little turn on it.
Thank you.
Can I say, from the appellant's point of view, one of the reasons for, in one sense, perhaps not drilling down into the details of JS2 was for two reasons. Firstly, the clear position of the Crown, as I say, which is to rely on JS2 as being part of the reason why they argue that the proviso should be applied in relation to the jury. That, we would submit, is a clear indication of the potential importance of JS2. The other is that, as I've already indicated, the clear indication is that this was a case where, in particular, the only direct witness, Mr. Chow, was someone who appears to have been regarded as unreliable by the jury on the basis of, given the acquittal I've already drawn attention to. And that demonstrates the potential importance of the technological evidence. Can I go back, though, to the point that the reason I was talking about what was being argued below and drawing attention to the fact that there was no debate about the, it's clear, it was accepted that there was an argument that JS2 should be not admitted in light of the Charter, and in particular the breach of the Charter. The reason I draw attention to that is because effectively what the Crown does is argue that what is now being put before this court is a new point. That's a part of the Crown's response. In summary, we don't accept that is right for these reasons. Firstly, as I've already indicated, it is clear that the issue of a breach of the Charter was before the trial judge. That's accepted. Now, the arguments may be different, more nuanced, may rely on authorities that weren't being raised at trial, but that doesn't mean that the issue wasn't before the trial judge. Linked to that, clearly the Court of Appeal's question that relates to this matter is premised on there having been a breach of the Charter. All the way through, and I can give you the references in a moment, all the way through, from trial court up to Court of Appeal, the way in which this matter has been dealt with is on the basis that it appears to be accepted that there is an issue in relation to the Charter, and the question was, what implications should that have? And that's why the Court of Appeal then, we would say properly, referred a question about the approach that should be adopted by trial courts to evidence that's obtained in breach of the Charter. And so we don't accept that this is a case where we're prohibited in some way from arguing what we're arguing. We're arguing the same argument, the same issue that was raised at both courts below, albeit perhaps slightly more nuanced. Now, in terms of the nature of the breach, because our case accepts that there is no automatic rule that a breach of the Charter will inevitably lead to exclusion of evidence. It is a more nuanced argument than that. It's important in one sense to be aware of the nature of the breach. And in one sense, the starting point in our submission in relation to that has to be the legislation, the section 16. Yeah, section 16 of the Interception of Communications Act, which is at 6277, the relevant passage, section 16, the Act, and that is section 16.2, and it is not a complex piece of legislation, which is probably a virtue. It requires a designated person to make a request, and it requires an authorised officer to receive the material. Designated person is defined. Section 16, page 6276, the preceding page. Designated person means someone who's prescribed by the minister. Section 2 defines what is an authorised person, authorised officer, and that's at 6257. It's a number of specified officers within law enforcement. Two other features of this legislation that are worth noting. Firstly, if you go to 6279, section 17 links compliance with section 16 to admissibility of evidence. And section 4 demonstrates in one sense that what this Act is about, consistent with the terms that of the legislation that I've taken you to already, because section 4 is concerned with warrants, essentially, for interceptions. And what that demonstrates in my submission is what this Act is about prescribing safeguards in circumstances where what the Jamaican state is, and what Jamaican law enforcement in particular is seeking to do, is interfere significantly with the rights of individuals to privacy. So it is a piece of legislation that's intended to put safeguards in place, and clearly requiring officers of sufficient seniority, essentially, to authorise gathering of data. It is an important part of seeking protection, of protecting the rights of privacy. Now, in this case, Corporal Brown was the officer who made the request, as I'm sure you've picked up. He said expressly that he was at page 1631 of the bundle, line 19. He said expressly that he was familiar with the Act, and that was hardly surprising because his whole role, as he gave, which he, according to him, when he gave evidence, was essentially to make requests under this Act, and you see that at 1574. Line 5, on line 5 to 13. Now, there's been an issue about what he was cross-examined about, and that's raised by the Crown in their case. He was cross-examined about his knowledge and a compliance with section 16. If you go to 1632 in the bundle, he expressly said that from line 24 on until line 4 the following page, that he knew that there needed to be compliance with section 16, and he believed that the notice that had been sent to Digicel complied with that. Now, that is in one sense a slightly surprising answer, given what he says almost immediately afterwards, because he was then cross-examined about the need for a designated person. And if you go to 1635 from the top of the page, he recognises that section 16 requires a designated person. He recognises that he wasn't designated. Says that twice, in fact. I'll just give you the reference. He also says it at page 1641. And so on the face of it...
He's not designated, but he is authorised to receive.
He claims he's authorised to receive. I think it's... The Court of Appeal found he wasn't authorised to receive, but he...
The judge accepted he was in the voir dire.
Well, I'm not sure the judge actually expressly ruled on that, but certainly the Court of Appeal was of the opinion by the time that they'd got no evidence that he was an authorised person.
Well, did they get other evidence other than that was produced in the voir dire before the judge, where this matter was fully explored?
Well, the problem is, if you look at the evidence, there's his assertion that he's an authorised person, but he clearly doesn't come within the terms of the legislation, and there's no evidence there was no evidence that I can find that indicates how he gets authority when the terms of the legislation are clear. Similarly, that's why I assume the Court of Appeal said what it said, because on the face of it, it's difficult. Although that was his answer, he clearly doesn't come within the definition, and there's no evidence to explain how authority was in fact given. So that's why I think the Court of Appeal, I don't know, slightly speculating there, but that would be a good reason for the Court of Appeal to say what it said. But it may not matter, because in one sense, there was non-compliance. There clearly was nobody disputes there was non-compliance, and that may matter to some. I suppose the way in which it may matter is it may go to how serious the breach was. But I mean the clear problem here in our submission is Corporal Brown is saying, and I'll give what I understand may be his answer to this in a moment, just take you to it. Corporal Brown is saying, I know about section 16. I know you need a designated officer. I know I'm not a designated officer, effectively. So on the face of it, that's a problem. Now, what he does suggest is, if you go to 1643, and this is all just to make clear in the course of cross-examination, which is clearly intended, we would submit, to determine why this breach occurs, and at 1643, 2022, line 22, not 2022, Corporal Brown indicates that there may have been, that others may have been designated.
He names it.
He names them, yes.
922.
Yes. He names two officers, ASP Pascoe and Inspector Williams, as potentially others who may have been designated. But he accepted, if you go on to 1646, that he did not know whether or not they'd had the benefit of an affirmative resolution. And you will remember that the terms of the legislation are clear, that you need an affirmative resolution. And he accepted that he, in one sense, he needed to rely on them having that authority, because he accepts at 1652 that he knew the request was not from a minister. And so you have on the face of it Corporal Brown saying, I know what the legal obligations were, but essentially I've assumed compliance with them. And you see that reference to assumption, that's his language, not mine, essentially, at 1653, lines 13 and 14. And that, in our submission, suggests that this isn't, that there is at least a degree of negligence, essentially, here, in the sense that this is someone who understands it's his job, he understands that he is subject to legal obligations. He doesn't check, effectively, compliance with those legal obligations.
Doesn't he at some point say that advice had been taken?
That's, I think, if I remember rightly, there is a reference to that. I think that may be the Digicel witness from memory. I'd have to double check that. Because, but I think it was there was reference to advice, but I think that was the Digicel witness.
Perhaps we can come back to that.
Yes, but my learned junior has confirmed my memory is.
Thank you very much.
I'm always just a little cautious about saying things on my feet, but I think that's right. Yeah. It was the Digicel witness. And of course, the other factor here, which is something the Court of Appeal highlights, is that the Court of Appeal had already, by this stage, by the stage of the investigation, not the stage of the trial, but by the stage of the investigation, made clear that there was that what the terms of the ICA were, the legislation were, in a judgment called Phipps. And the Court of Appeal point this out at 137. So it wasn't as though, I mean, the problem with taking advice was that that might have explained an initial failure to comply. But if you look at 137, which is 5828, they highlight the fact that Phipps demonstrated a flawed approach similar to that adopted by Corporal Brown. And that raises the question of, in one sense, even if Corporal Brown is effectively the relatively low-ranking officer who perhaps hasn't picked up the latest Court of Appeal judgment, why action wasn't taken by those in command of him? And that's one of the things that the Irish Supreme Court have emphasised when looking at responsibility for compliance with constitutional rights. It's not simply the person who's on the ground that you need to worry about. It's what happens higher up the chain and why the system essentially was operating the way it was. I mean, this was a situation where the Jamaican police had been told in Phipps, your process is wrong. And yet, there was no evidence essentially explaining how you then had Corporal Brown making the same mistake or a very similar mistake. Now, the Crown argue that it wasn't put effectively that the police or indeed Digicel acted negligently. A few things about that. Firstly, it was the Court of Appeal themselves who essentially pointed out the non-compliance with Phipps and the issues that arose in relation to that. Secondly, but perhaps more importantly, the word negligent wasn't used in cross-examination. I accept that. I can't find any reference to that. But the questioning clearly focused on the actions, whether effectively the actions of the police demonstrated that they were disregarding their legal obligations. What the questioning was focused on was how Corporal Brown had been in this position when the provisions were clear. Thirdly, in any event, I'm going to come on to make the point, based on case law, particularly Mohammed, that the burden was essentially on the prosecution to show to explain essentially why there'd been non-compliance with the law. And it should be noted, just one reference in relation to that is of some significance. If you, at 1966...
There's no reason to think, had Corporal Brown been designated and authorised, there's no reason to think that this material would not have been provided. There was no substantive reason why that material wouldn't be provided, is there? I'm just asking.
Well, the way in my submission to approach that, and it is and can I, in one sense, take issue with the way the question's phrased rather than, and I will answer it directly if I can as well in a moment, but I'd take issue with the question. In our submission, if the Crown is going to say it doesn't make a difference, it has to adduce evidence of that. Now, in a case like this, the role of the Minister and anyone who's been designated by the Minister is important, because it is essentially intended to act as a check. It's intended to ensure that the police can justify a substantial interference with privacy rights. Now, the way in which you potentially would have been potentially open to the Crown to call, for example, the Minister or someone they designated and say, who could have said, I'm the designated person, I've looked at this, there was a good reason for making it. That material wasn't produced. So one simply doesn't know that. So
the investigation of a very serious criminal offence targeted at people alleged to have been involved in that very serious criminal offence would have justified disclosure of this material?
Well, you need a sufficient, I mean, you can't, because of the privacy material,
okay.
you can't
so you don't
just,
accept?
I don't accept as a matter of principle that you need enough, you need a good basis for believing that evidence may be relevant. Of course, I mean, the whole point of the legislation, it seems, we would submit, is to strike a balance. So it's to recognise that there may be circumstances in which the evidence will be of value and to enable a route by which it can be obtained, but restrict those circumstances by putting checks in place. So that's why we would submit that on the material available, one simply doesn't know whether a designated person would have. And
whether a designated person would have made the application.
Sorry, whether the designated person would have authorised it. Yes.
Well, the designated person doesn't authorise the notice to...
Yes, because that's, in one sense, the author... My lady was asking me the point about designated officer and authorised officer, and in one sense, the designated officer, in a very real sense, the designated officer is the more important safeguard, because he or she is the person who gives authority, and they're the one who needs to ensure that there's a sufficient justification. I assume the reason why an authorised officer is needed to receive the material is to make sure that its privacy is subsequently protected.
Yes.
But the authority is given by the designated officer, and they're the person, in one sense, who is perhaps the more important safeguard.
Well, how do you square that with your submission about the importance of the material?
Well, when we look at the material now, we know that the material found was important. But that doesn't mean at the time the application was made, there was justification, because obviously when making the application, you don't know what, as far as I'm aware, there was no reason to believe that there was knowledge essentially of what that material would show. That doesn't mean it wasn't justified making the application. It may be that the officer had sufficient information to demonstrate that there was reason to believe there were telephone communications. But we now know the relevance of that material. The question that we don't know in my submission is whether a designated officer, knowing what was known at the time the request was made, would have been satisfied that the justification outweighed the interference with privacy. And that's an important safeguard. That's clearly why the requirement for a designated officer exists. It's to stop fishing expeditions. It's to ensure that there is a proper basis for making the application. So that, can I just draw attention to one other reference in the material about this, which is going back to the point I made about the need to, in one sense, have material about the system and how Corporal Brown wasn't effectively given clear directions as to what he needed to do with. If you go to 1966 of the authority, not of the authorities, of the electronic bundle, line 10, there is a submission there made by the Crown, albeit one that's made apparently without without an evidential basis expressly for it, because no evidence was called in relation from a commanding officer, as far as I can see. But in support of the submission that Corporal Brown was acting in good faith, the reference was essentially that this procedure had been dictated to him. Now, that raises a question. That's why, in one sense, we submit it's striking that there was no evidence about the command structure, how this system had been allowed to remain in place, despite the clear terms of Section 16, and despite the clear terms of Section 16, and despite the judgment of the Court of Appeal. And the Crown makes the point, or argues, essentially, that the defence didn't argue that Corporal Brown's acts were, they didn't challenge the submission that Corporal Brown's actions were in good faith. Firstly, we would submit that making whether or not the actions were in good faith sets up a false dichotomy. Essentially, there isn't in our submission a simple distinction between actions that are in bad faith and all other actions. The reality is that breaches of constitutional rights, such as those in this case, fall on a spectrum. For example, somebody can act in good faith but still be negligent by simply not paying sufficient attention to their legal obligations. They can act in good faith, but there can be a failure by those in command of them. Secondly, the submission that is highlighted by the Crown about good faith was essentially an argument that good faith was irrelevant to the breach of the legislation. It wasn't essentially a submission about how the court should approach the consequences of the breach. In terms of the consequences of the breach, the submissions, as I say, were pretty clear that there was an argument, essentially, that there'd been a breach of the Charter and that should lead to the exclusion of the evidence. And the trial judge recognised the significance of arguments about the breach of the Charter. The trial judge, if you go to 2237, bottom of the page, lines 23, the trial judge indicated he recognised the force of the arguments that there'd been a breach of the Charter, apparently accepting that there'd been a breach of the Charter. But at 2240, at lines 13 to 20, essentially, he cited Khan, and in particular, 2240, he cited Phipps, which is the Jamaican Court of Appeal Authority, which indicates that...
I think he cites Khan on 2240.
224, well, right at the bottom he cites Khan. He cites Phipps before Khan. Sorry,
I
was misreading my own notes. I'd gone to 2241, and that's what was slightly confusing.
Yes, I see. 2239.
Yeah, he cites Phipps. He then cites Khan. And what he does at line 20, rather, at 2241, is he indicates that essentially that the breach of the convention does not mean the trial it is unfair. And applying Phipps, if you then go over to 2242, line 17 onwards, he indicates that the issue is relevance and not how the material was obtained. So on the face of it, particularly at 2242, what he's doing, applying Phipps, which itself goes back to Khan, which we submit is the wrong approach, he directs himself that the only issue really is the relevance of the material. It doesn't matter that it was obtained in breach of the Charter. And that's, we would submit, the approach that was adopted by the Court of Appeal as well. If you go to 5833,
Sorry, page?
Page 5833, 147. You see the application of King and Phipps, and then if you go on to 5836, top of the page, which is the end of paragraph 150, the judge adopted essentially the correct approach. The indication is that the judge adopted the correct approach applying King, and that led to the rejection of the arguments about the Constitution. And so the Court of Appeal proceeded on the basis that there was a constitutional issue raised, a charter issue raised, but rejected it given the application of King and given the application of Phipps. And we submit that is a misdirection, and that had this been approached properly, given the evidence I've taken you to, and in particular the absence of evidence to explain essentially the how it was that Corporal Brown, despite apparently being aware of his legal obligations, didn't ensure that there'd been compliance with those legal obligations, we submit that in those circumstances that the evidence would have been excluded. Now, the reason we submit it should have been excluded is this. Firstly, it's important to start with the Constitution and the Charter. And the Charter in our submission, the reason for that is that we submit, obviously, that it's important to look at what the Charter itself says to see what approach essentially should be adopted to breaches of it. And the Charter is electronic bundle 6248.
6248. Thank you.
Just before you move on to this, are you submitting that the approach in Phipps and King is that one is not concerned at all with how the evidence is obtained, that there's no discretion?
I'm submitting this, that King and Phipps, certainly the way the judge understood this, and I wouldn't disagree with this, is concerned ultimately with the impact on the fairness of the proceedings, not how the material was obtained. Now, there are circumstances possibly where how the material was obtained may have an impact on fairness. I mean, if you torture someone, that would probably have an impact on fairness. But the critical difference between that and Muhammad, which is what the approach of this court to written constitutions, is that what Muhammad does in our submission is recognise that there is a significance in a state incorporating rights within a written constitution, effectively elevating those rights as being ones that have to be given particular weight, and that even in circumstances where perhaps there isn't an issue about fairness, what the court needs to do is balance the unfairness, sorry, not balance the unfairness, balance the nature of the breach against the interests of the state in admitting the material. And so the fact of a breach has to be given weight. And Mohammed recognises that that is a different approach to King. He expressly says that.
So do you not take into account the fairness, the impact on fairness as part of that balancing exercise at all? You just weigh breach as against interests of the state in disclosing?
Well, you can't, obviously, because you have a constitutional right. Now, I'm not arguing you can have an unfair trial, but the nature of, but what you can have in my submission, that I'm not saying you wouldn't take account of that. What you can have is a situation where the nature of the breach is sufficient on its own to justify exclusion, because the nature of the breach...
Yes, no, I understand that, but I thought in answer to my Lord's question, you were saying you don't any longer, as a result of the Charter, have regard to the impact on the fairness of the trial.
Can I just slightly modify my answer? I was referring to Mohammed, and we obviously go one step further, arguably, by referring to the Irish case law. So we would potentially go a little further, and I'll come on to the Irish case law in a moment. But before I do, what I was trying to do, just to be completely clear, is draw a distinction between the King and Phipps approach, which is simply focused on the fairness of the trial, and doesn't necessarily give any weight to the significance of the breach, and the Mohammed case, which does give weight, and very real weight, to the significance of a breach because of the importance of a written constitution. If I suggested that fairness wasn't a factor, then that was lazy language on my part.
So you accept it is a factor?
Yes. It has to, yes, I would accept under Mohammed it has to be a factor. Yes. Yes, but as yes, just to re-emphasise though, the critical point about the Mohammed case law is it gives weight to the inherent significance of a breach of the Constitution, and so it can lead to exclusion simply on the basis that there is a need to protect and vindicate constitutional rights, and that's the distinction we would draw. Going to the Charter,